Critical documents, employees, contractors, and partners. Prepared for and presented at the 2014 Square One Entrepreneurship Training Program. Square One is a program of the Center for Emerging Technologies. CET is an affiliate of the Cortex Innovation Community. Square One is funded in part by the Missouri Technology Corporation.
And it's good to be here. I've moved the table over here because I made a few notes as the earlier presenters went through to try to pick up on some things that came to my mind. So if I'm looking down at here, that's what I'm trying to catch up on. And they won't be on the charts you have, but hopefully maybe we can fill in a couple things. So I am going to talk primarily about what can broadly be described as technology-related agreements, transactions and agreements associated with the transfer and exploitation and commercialization, if I can talk, of technology and intellectual property rights. Now, we've already had a fair amount of discussion tonight about confidentiality agreements. I've got some of that material in my handout. I'll not go through all of that. We'll try to avoid duplication, but I'll again emphasize what Brian said is a very, very important type of document to consider using in many aspects of your business. Another variety of that is a material transfer agreement. I don't know how many of you are in the bio field here. I'm sure some of you, but those will be particularly of interest as you get along the road in transferring samples of chemicals or biological materials and things like that. You'll get into the realm of material transfer agreements. Services agreements, we talked a little bit about those already, but things with consultants, laboratories, programmers, web designers, all that sort of thing that you might have done by folks that aren't employees. I'll hit a little bit again on employment and consulting agreements. We've covered a little bit of that already, but maybe I can fill in a couple points. And I'll also maybe add a little more than I thought I was going to at the beginning on license agreements when we get to the end, because once you get into this area a little bit further, you begin to have products that are nearing development or close to where they're going to need some other folks to help you develop them. You're going to get into things generally within the category of license agreements. We could make a whole presentation on that, but we'll try to hit some of the high points.
Excuse me.
Uh-huh.
I know this is a bit premature, but could you, no one really talked about, and perhaps if you can't really, but in doing software or a mobile app, how it can be patented, and especially when there are features that are commonly used.
Mm-hmm.
For instance, if you're going to use a bar scan, there are a lot of apps out there with bar scans. How does that work? Is it just simply slightly changing the technology
Right.
or the code ever so gently, and then it makes it different? And what if there's nothing that technically you've done to change things? It's just a matter of the arrangement, so to speak.
Right. Well, first a disclaimer: I'm not a patent attorney, and what you're asking is potentially a very detailed patent-related question. Now, there's certainly, I know enough to know that there are software patents out there, many of which have been granted and cover things of the nature that you're describing. And Brian could probably talk to you about the sort of the requirements for what might make a software patent eligible for patentability, you know, a machine and conversion and things like that. Now, generally when you talk about software, you're going to talk about, at least at a minimum, copyright protection. So the specific instance of your code may be copyrighted. Patent protection, whether it's available or not, will depend upon the novelty and the non-obviousness of what you're doing. So again, if it's out there, whether it's patented by somebody else, it's been published, it's in the public domain, you very likely may be out of luck on the general idea. Now, there could be a nuanced improvement or modification of that publicly available idea or publicly known or patented idea that might be subject to a patent application. It might be subject to a patent itself, but that would involve searching the prior art and trying to identify perhaps some element of what you have that is in fact novel and non-obvious when compared to other folks' products and or patents. And I'm going to speak out of turn, Brian, but non-obviousness, correct me if I'm wrong, is, I mean, there could be two pieces of prior art out there that don't talk exactly about what you're doing, but it would be relatively obvious to someone reasonably skilled in the art to put those together to do exactly what you're doing, and that is kind of the essence of the non-obvious problem. So I would talk to a patent lawyer a little bit about the details of your idea. Software patents are available, though. You can do it. But the idea of barcode scanning, things like that, it's a fairly ubiquitous. So that kind of raises flags that there may not be a patentability option out there. As sort of an intro into some of the things I'm going to be talking about, you know, we've talked a lot tonight about intellectual property rights. And there is a subtle distinction between what I describe as technology and intellectual property rights. Technology can be things that are tangible and intangible. Technology could be a sample of something that you've got. It could be a piece of hardware, or it could be ideas and processes as well. Intellectual property is essentially all intangible. It is a legal right. Sometimes when you're exchanging things with people or creating things, you may be creating technology and you may be also developing an intellectual property right, but they are somewhat distinct, and we'll get into that a little bit more later when we talk about, you know, what do you need to address, one or both, and the bottom line is never give away more than is necessary, and we'll get into some examples of that. Confidentiality agreements, we've gone over those already tonight, but essentially creating the contractual framework within which we can disclose information we think is confidential or proprietary to us. Typically, they arise in the context of a discussion with another party about the evaluation of a potential business arrangement or relationship. If you get to the point where you are actually entering into a production agreement, a distribution agreement, a consulting agreement, some other form of what I would call generally a definitive agreement, you may very well and probably should include confidentiality provisions in there. Typically, confidentiality agreements alone, from business to business perspective, will cover the pre-agreement talks, the negotiation phase, where you need to learn a little bit about each other to enable you to decide whether you want to do the deal. Brian went through a great discussion of, you know, don't just blindly go in and say, oh yeah, I'll sign a confidentiality agreement, no problem. You know, carefully evaluate the need to do so. And the other thing is, you may get into a situation where a party says, well, I'm not going to talk to you unless we have a confidentiality agreement. And you may find them to be an important potential partner. You want to do it, so you enter in the confidentiality agreement. That doesn't mean you have to share confidential information. It only means that if you do, you are protected. Still, always keep in mind never to disclose more than you think is reasonably necessary as you progress through those discussions. You may have a confidentiality agreement that's airtight, got it pretty well locked down, but at the outset, you may just sort of trickle this stuff out just enough to kind of keep the negotiations going. Don't give away the family jewels in your very first meeting unless you really need to. Okay? Brian had a great list of items. This is much the same. One thing I'd like to mention, at least I think maybe a couple things. One is available remedies. If you see a form, it ought to have a reference to what we call injunctive relief. If someone is disclosing your confidential information in violation of the agreement, it's nice to have an agreement that says you're entitled to seek injunctive relief, which is basically nothing more than a court order telling the other party to stop doing what they're doing. We talked about the one-way in or out or the two-way. You know, evaluate what's really going on and try to limit the agreement to what's actually needed. Realistically, I don't see in my practice a lot of one-way agreements because the other party tends to feel slighted when they don't think that they're protected. But if it's the right thing to do, stick to your guns. Warranties and disclaimers, I think we covered that. Trade secret or proprietary information. Now, we talked a little bit about the duration of the confidentiality obligation. You'll see a lot of agreements with 2 years, 5 years, 7 years is stretching it a bit. I've even seen some that have terms as long as 10 years. But if you think you're going to be disclosing trade secret information, stuff that under the statute in Missouri, for example, that would be considered a trade secret, as long as you have taken the proper steps to protect that, there is no expiration of that. And the Koch formula we talked about earlier is the perfect example. It's a trade secret. It's been protected for, I don't know, how many years. It still qualifies as a trade secret. So if you think you're actually going to be disclosing that, be careful. But you can have agreements, confidentiality agreements, that will say something along the lines of, with respect to the trade secret information, you must protect that information for so long as it is a trade secret. That's an important consideration. This is just an example of a definition of what's confidential information. It's in the packet. We don't need to walk through that. Permitted use, again, try to be detailed and limited only to the context you need. They'll typically talk about what is or is not a permitted use of the information. We talked before about disclosure as one thing and use being a different thing. I like to see language along the lines of, the only thing you can use this for is to evaluate the potential relationship between you and me. That's it. Another element that you'll often see, and I like to put in the ones I use, is the no obligation to proceed. Just because we're sharing confidential information should not be deemed to create any obligation for us to go forth and enter into any type of a definitive agreement. We're just discussing this. I don't have any obligation to you by the mere fact I'm receiving confidential information from you to actually enter into a contract with you that goes on from there. Secondly, no express or implied license is granted. All right, just because I've disclosed this to you doesn't mean I'm granting you a license to use this in any way that's not expressly permitted by this agreement. We sometimes do a little bit of belt and suspenders, but it can really help to hammer the point home in someone receiving that information. All right, I'm going to move on a little bit to what I generally call services agreements. Some examples, and we've talked a little bit about this already tonight. Consultants, programmers is a great example. Web designers is another good example I see a lot of. For the bio world and other folks, maybe lab services, testing services. It can be a large variety of things. What we're talking about generally is hiring someone outside of your company to perform some service for your benefit. Some key things to keep in mind when you look at these and try to put them together. What is the scope of the services? And my mantra is just please be as clear and as definite as you can. I see all of the time people saying, service provider will perform the services set forth on the attached statement of work. I'll go back to the statement of work, Exhibit A to the contract, and it'll say, those services as described by a company from time to service provider. I don't know what that is. I don't know what they were supposed to do, and if my client ever had to go and enforce that to say, you didn't do what you were supposed to do, how can we enforce that? So it can come down to an element of how enforceable is that contract. The second part of that is, what is this party going to do on day 2 once they've signed the agreement? If everything is spelled out cleanly, it gives everyone an idea of exactly what that service provider is expected to do, the timeline in which they're expected to complete it, maybe even the methods and processes that they're supposed to use, what your deliverable expectation is at the end of the contract. You can put any number of SALs, statements of work, on these contracts. You can make provisions for amending them as things change, but at least you've got some basis when you have to pull this thing out of the drawer when a problem comes up to say, you were supposed to do X, Y, Z, and you only did X, Y. and I'm damaged because of it. Yeah.
I have a question. Actually, it came up today with my company I work for now, but we had a client who we typically write a statement of work for when we do new work for them, but because of the process that he needed to get through his legal department, he wanted just a shorter letter of agreement.
Mm-hmm.
And just thinking for my own business moving forward, as you gave details on being as detailed as possible.
Mm-hmm.
Sometimes those documents become very lengthy and they scare people away.
Yeah.
And I don't know if this is a question or just a statement. I mean, don't you have, to a certain extent, sometimes you have to measure
You do.
how much detail you,
Yeah.
okay, all right.
It is often an exercise of establishing what the priorities are and trying to work with your partner to get something that can actually get executed at a reasonable cost and in a reasonable time frame. Certainly, those are valid business conditions. I have seen some folks, and I've used this process myself from time to time, in creating a somewhat shorter agreement itself that isn't what I would call fully loaded, and it's done so in an effort for them to help get that through their procurement group, and then the statement of work could be attached at a later date once the parties have actually negotiated and sat down and planned through it. There's nothing that says the services agreement couldn't say, from time to time you will perform those services as set forth in separate statements of work, to be attached here to, as they're put together, and I hate to hide the ball, but sometimes, to get something started, you can get something like that in place, work closely with them then to, develop the statement of work that's reasonable, attach it on. That might be something that would be useful in those circumstances. In other times, you just, okay, is my risk here, worth the benefit I'm going to get out of it? And it depends on how critical the thing is you're looking for to get done and how much money you're going to pay. As was already mentioned, key part of this is to clearly say who's going to own what. We already talked about the default rules will surprise you. Me paying money to someone to do work for me does not equal I own what they give them in the legal world. It's as simple as that. And time and time again, I will talk to people, I paid them to do that, they delivered it to me, it's mine, right? No, not necessarily so. I may own that copy of it, but I may not own all of the intellectual property rights to it. Be very cautious about that. We talked about getting the proper assignment clauses. One other thing to consider is, how do I get out of this mess? As lawyers, I think we already talked about, seeing the worst, planning for the worst. So what happens when I've fallen in love with a service provider that's going to write code for me that's, they're great. They're just going to, this is going to go out of, they're going to hit it out of the ballpark, and they never get anything done, So please plan to how to get out of it. Plan for failure. My view is that if I'm paying a service provider to provide me service, I want to be able to terminate that relationship at any time I want. Now, I don't always get that for clients. Sometimes service providers will have to dedicate resources, make plans, shift people to do your work, and in turn they expect some continuity of those people. In other words, they're not going to let me call them on the phone and say, stop work, this agreement is terminated effective tomorrow. Because they will have said, I've made an investment to get this work done for you. That doesn't fly for me. But you should be able to, as a purchaser of the services, get out of that relationship within a reasonable period of time. You're probably going to have to pay for the services that were completed prior to the work being terminated. You may not be able to get out of that, but try to avoid a situation where it's going to be very, very messy for you to end the relationship. Because,
One of the clients I'm working with, and I'm providing services, so I'm a little bit on the other side. In his agreement, it says that we're contractually bound for a full year, but either of us can terminate in writing. And I didn't feel comfortable obligating to him for a full year. Then I was told by somebody that's a normal clause in contracts, but I don't know enough about contracts to determine that.
well, it can depend upon the types of services that are provided. For example, if I'm hiring a company to come in and manage my internal computer network in my office to perform things like maybe routine computer maintenance, update my machines with the latest patches, fix my printer, I want to be able to engage that service provider and know that he'll be with me for a year. You know, I don't want to have to renegotiate with somebody new. So I may ask for that. But again, on my end, if they don't live up to their obligations under that agreement, I want to be able to end it.
And what I'm offering has a specific term.
Well, typically, you know, you would see in a contract something like the term of this agreement is for 1 year. And then you might have a termination section, you know, and the contract would say, you know, something along the lines, subject to earlier termination as provided below, this contract will be in place for 1 year. Service provider may terminate under the following circumstances. Client may terminate under the following circumstances. And it'll spell out how and when each one can do it. But unless those occur, at least there's some comfort that they're going to be receiving services for a year. And on your side, you have some services, some comfort that unless I mess up or this guy goes out of business, you know, I'm likely to have a contract for a year.
See, but my term's much shorter. My term's 2-3 weeks. It's not a year. And I don't want to commit to one client for a full year.
Oh. Well, that may just be something that you just have to negotiate. Yeah.
Okay, but I should work that out.
I would, yes.
Is there a formal name for a document that, and specifically, if I have a logo design, I love it and I want to stay with it. I have my website design and I want to stay with it, but now I'm learning that doesn't mean I own it. Is there a formal name for the document or agreement to get the ownership and to be sure that that's covered?
Well, if you're talking about excuse me, I have a bit of a cold. If you're going back after the fact, it's been created, you've been using it, there is probably in that case something just called an assignment would work. Now sometimes we lawyers throw in some Latin on the end of that, assignment nunc pro tunc, that's how I pronounce it. It just means now for then. Mainly, I'm going to sign it now, but it really was effective as of back then. Yeah, but just an assignment document. You know, if I had a services agreement and it didn't actually have that language in there, I would go back to them and try to work with them and say, look, you know, I've had some legal advice. This is, you know, our understanding as I understood it was that this was to be my logo. I'd own all rights of it. I need some documentation in my files that says that clearly. You know, would you mind please signing that?
Let's talk about the intellectual property and farming out, say, you farm out some of the work to be assembled. You've got a company that's going to put the circuit boards together for you. You have another company that you sent the artwork out to have them do the circuit board design and stuff like that. Now, does that mean once this assembly is put together, that's still mine, correct? In other words, I'm farming out the assembly of the product.
Well, if each of those individual pieces were created by a service provider, like say a circuit board design company, and you had a sufficient agreement with them that, you know, the product that they delivered to you, you captured the intellectual property rights to that, and then the same thing goes over here. When you put it together, I think you would be covered. Now, are you doing the final putting it together, or is?
This is just something in the future.
Oh, okay.
All the design stuff on those
Right.
prototypes are being done by us.
Okay. Some other key issues in the service agreement realm. Will the service provider stand behind the work? Look for proper warranties. If you're expecting to get a product to do X, Y, and Z, or meet certain written specifications that may be set forth in the statement of work or the functional requirements document or whatever caption might be put on that, try to get some nice warranties that say the work that we will do will be done in a good and workmanlike manner or professional and workmanlike manner and will comply with the specifications set forth in this agreement. That's not too much rocket science, but a nice clear statement that what they provide you is going to do. Now, in the science realm, oftentimes people are out there doing development work for you. There may not be a guarantee that what you're working on will in fact work. Then maybe what the warranty would be, we will follow accepted standard procedures in our lab. We will follow the processes you've laid out, and maybe that's as far as it goes. We can't make a guarantee that this molecule will perform in a certain way in a certain environment. That's can get to be unreasonable, and no one would probably sign up for that. But in many other areas, service providers should be able to provide you with some relatively strong warranties. Warranties of non-infringement. Okay, the processes I use to do the work for you and the work product that I give to you will not infringe the intellectual property of any third party. Now, there are a lot of nuances on that, whether it's an absolute broad warranty, whether it's a somewhat narrow warranty, whether it is a qualified warranty. Those are all things that attorneys can help you work through, but it's something to look for in the service provider's agreement. Indemnification, basically that sort of thing. If I didn't do for you what I told you I was going to do for you and you suffer or incur damages because of it, I will protect you. If I told you this software I wrote for you was original to me, it didn't infringe anybody else's software, and you end up with a claim of infringement, they can stand in between you and them, or the complaining party, and protect you. Be aware indemnification really is only as good as the party that stands behind it. They may be somebody working out of their garage and have no money, but they can write great software. Their indemnification is probably not going to be really valuable to you. Along the lines of indemnification, if it's an established company that's providing services to you, you may want to ensure actually that they have certain specific insurance in place to cover their workers comp, auto liability, errors and omissions liability insurance, such that if those people working on your projects goof up and they're supposed to stand behind it, they've got the insurance to help them do it. That is something you'll see more in larger companies dealing with larger companies, but it's also available to anyone if it seems appropriate. Employee agreements, we talked a little bit about these. The agreements you're going to put in place with your employees, obviously we talked about confidentiality. I don't think I'll go into that again. Ownership of work product, again, default rules can surprise you. Make sure you get that assignment Brian talked about. Non-compete issues. And another one I think maybe wasn't mentioned was you might also include a clarification that this is in fact an at-will employment agreement, that either party can end the relationship at any time and for any reason. You can do that in Missouri, but just so it's clear between the two parties involved, that's the case. Now this is the eye chart, I guess, for the evening, but it's in your materials. This digs down a little bit more into some of the actual legal language you might see in an employee agreement with respect to confidentiality. Note that we talked about some of the things to be aware of. Use, disclosure, those kinds of words are actually used in these things. During or subsequent to the employee's employment by the company. Here's one that we didn't cover earlier. Employees shall not disclose or utilize in their work with the company any secret or confidential information of others. So if you hire a programmer that just came from one of your competitors, you want to make sure that they're not going to bring in to your shop something that's going to contaminate the work that they're doing for you. That can cause a real problem for you. There you are unintentionally incorporating into your company's business something that actually belonged to someone else. Provisions of the, this just talks about this surviving after termination. Another thing in here that is worthwhile to have is that employees shall deliver at the termination of their employment or at any time you ask all copies, notes, etc., etc. In other words, if you're going out the door, you've got to give me everything. You don't get to keep anything. But you can read through those. They're in the handout. Similarly, when we talk about employee inventions here, it's referred to as innovations. Here's a sample of some detailed language. Talks about, one, their first right is to disclose to me as their employer anything that they come up with during the period of their employment. And then we can get into a little bit of the scope of what this covers that are along the lines of the business, work, or investigations of the company or company's subsidiaries or affiliates, which employee's employment relates, or as to which employee may receive information, result from or suggested by any work, otherwise made through use. And these are all the sorts of things that Brian mentioned earlier about I can't claim everything they do in their entire life so long as they're employed by me. I have to make it somewhat reasonable. Here's an example of some detailed language that works around that issue. Here's the assignment part. Employee agrees to assign and hereby does assign all of those things that I've earlier defined as employee innovations to the employee. It goes on to say that the employee is responsible to make adequate and current written records of all those inventions, and during and subsequent to his employment, he will, without additional compensation, execute all necessary papers or otherwise provide proper assistance. There may be other documents that need to be signed. There may be interviews that need to be made. There may need to be questions asked by attorneys. You want to kind of do the best you can to get that employee on the hook to help you out with whatever is needed to perfect your right as the employer in that intellectual property right. This is a similar example of a non-compete. Non-competes, the other two issues, the employee inventions and the confidentiality, clearly must have, need to have, don't go home without them sorts of things. The non-compete, it can be a little bit more based in the particular circumstances of what's going on. Certainly, there are going to be people potentially on your staff that it's not really important. It could be maybe admin help. It could be, more of sort of a routine labor that's done. You have to, take care with maybe where you use it. But if it's a researcher, a principal investigator, one of your key salesmen or account managers, you may very well want to consider a non-compete. People that have a good deal of knowledge, insider knowledge on the operations of your business, and if they decided to go out and work for your competitor, could potentially do you some real serious harm. Those are the ones. Judges and courts are somewhat loath to enforce non-compete agreements as a very general statement. They are enforceable, don't get me wrong, but you need to be careful and tailor the scope of the non-compete restriction to have some legitimate connection to your business interest. So that could be, your business interest could be global or it could be local. So this is where, again, people that work with these contracts all the time can be of help. For example, 2 years after the date of such termination. 2 years is pretty reasonable. I think in most fields, you probably wouldn't run into a problem with trying to enforce a 2-year non-compete. Now, that's not true across the board. If you're hiring programmers, software developers, I've heard where, their non-compete restrictions may be shortened because it's such a fast-moving field. People are changing, moving around all the time. Maybe a year instead of 2 years. They're a little bit more difficult to deal with, and just be careful with them. But please, don't be afraid to use them when you think it's appropriate.
For the purpose of this agreement, how do you appropriately identify who your competitor is?
Well, I have seen circumstances where you actually list them. I would tend probably not to do that. For one thing, they could be bought. They could change their name. I suppose you could say this particular company and of all its successors and assigns, to maybe try to cover that. I more often than not see it along the lines of, let's see, where is it in here? Engagement which is the same or similar to any business in which the company is engaged or which is otherwise competitive with any business in which the company is engaged during the employment. I think that's more common to see language along those lines.
It's okay, that's pretty vague. I mean, that's good for the business owner that it's vague.
Yeah.
So.
Yeah. Oh. All right, I'm going to try to zoom through here. There's the at-will employment. You can read that. So I mentioned early on that a lot of the other agreements you're going to get involved with may involve some form or aspect of a licensing arrangement. And that can be things that we call something as simple as a license agreement. It can be collaborative agreements, joint development agreements. Often, there are times where you're going to be exchanging or sharing technology or proprietary information that is protected by some form of intellectual property right, and the other party will need some rights to do certain things with it. Maybe only during a short period of time, maybe extending for a long period of time. So for our discussion sort of tonight, let's just call a license fundamentally a permission to do something. I'm going to give you permission to do one thing or another. I'm essentially granting you a license. And I'm going to grant that license to my intellectual property and my intangible property. So intangible property created and defined by statute, that's what we talked about before, patents, trademarks, trade secrets, and copyrights. And to technology deriving value solely from the fact that I've got it and no one else does. So what's, again, this just is more definition on the subject matter of what a license can include. Patents. Under the statute, the patent rights invoke certain magic words. Make, use, sell, or import. We always add that too. So when you're granting licenses or you're being granted a license and it's covering patents, keep in mind there's certain magic words there to think about. Maybe I don't have to grant somebody all of those rights. Maybe I don't need all of them. I don't want to give more than I have to give. So maybe somebody's going to develop something for me that I have a patent on, but they're not going to sell it. So why would my patent license grant say, you have the right under this patent to make, use, and sell that product? I wouldn't need to do it. So, trademarks. The statute itself says it is a violation of trademark rights for any person without the trademark owner's consent to do all of this stuff. Basically, use in commerce my trademark in a way that's likely to confuse or deceive the consumer. So when you look at the magic words with a trademark license, you'll often see things like use in connection with, as opposed to make, use, or sell. Getting down into the weeds a little bit here. The other bucket, copyrights, again, we talked about what that could be: software, literary works, artwork. One thing that did come to mind in the earlier discussion about copywriting things, and I think the idea was about copyright. I think there was a question up here maybe about copywriting software and various things like that. Or yeah. Keep in mind, copyrights only protect an expression, a particular expression of an idea, not the idea itself. So if I have a software that's copyrighted, the functionality of that software is not protected by that copyright. Only that particular expression, only that particular set of instructions is what is protected. Now, there's some gray around the edges, but that's kind of a good rule of thumb to keep in mind.
So it would not be, for instance, that code allows one to take a picture, but it would be that specific code, not the function of taking a picture.
Right, exactly. The last one in the bucket of the sort of buckets or silos of intellectual property rights: trade secret, creation of state law, not federal law. Basically, the law says, I can get damaged from you if you misappropriate, i.e. steal my secret stuff. But keep in mind that misappropriation of a trade secret will ultimately depend on the efforts I've taken to maintain that information as a trade secret. In other words, I don't disclose it to anyone without a confidentiality agreement. I keep it reasonably well protected in my shop, and it's not out there in the public domain. Different kinds of licenses: exclusive, non-exclusive, field limited, all sorts of ways to limit the fields, purpose limited, time limited. At the end of the day, you can create a license agreement that's carved up so many different ways. You can make it work for whatever it is probably that you need to make it work. You can be creative, very creative in the rights you give, the obligations you get back, the way you get paid, the way you pay people. So they're just, it's almost too broad to try to get into in too much detail beyond this at this point. But, keep in mind that exclusive licenses can have pretty severe impacts for your company if somebody's asking for an exclusive license to some intellectual property that you own. That should be evaluated very, very carefully. Even if you do give some sort of exclusive rights to somebody, you can use all of these other areas of limitations to try to carve out the narrow slice that is needed. And again, it's very important to think about when you're talking about license agreements. Am I granting somebody a license under my intellectual property rights simply to use a piece of technology, maybe a piece of hardware I'm giving them? Do they need to add, do I need, or do they need access to both intellectual property rights and technology? And never give up more than is necessary. So I'm going to try to wrap it up. It's been pretty fast, but so we tried to identify some of the types of agreements that might be important in an early stage company: the employee agreements, the services agreements, the invention rights agreements, the potential licenses, although we didn't get to spend a lot of time on that, some of the approaches and pitfalls associated with those. I think the takeaway is that these kinds of agreements can really have a material impact at the end of the day on the value of your company. And there are some legal issues involved that are often complex and not always obvious or intuitive. So please be careful, because there can be lots of room for problems. So, think through it carefully, and when you think there's an opportunity, for damage, please get good advice and go from there.